Legal Spirits, the podcast of the Mattone Center for Law and Religion at St. John's University. I'm your host, Mark Movsesian. Last month, the Supreme Court wrapped up its October 2024 term, and in this episode, we'll review the term's church and state decisions. The cases this term touched on several long-running themes in law and religion: the limits of public funding for religious schools, how states may define religious for purposes of granting religious exemptions, and the scope of parental rights in public education. We were expecting 3 significant church and state rulings this term, but in the end, only one turned out to be a major development. We'll unpack what the court said and didn't say about the religion clauses this past term. Joining me on this episode is my longtime friend, John McGinnis. John's the George C. Dix Professor in Constitutional Law at Northwestern, where he teaches constitutional theory, administrative law, and related subjects. He's the author of numerous books and articles. He writes regularly for Law and Liberty and City Journal and other opinion online sites, and he's a thoughtful voice on originalism and constitutional structure. John, welcome back to Legal Spirits.
Well, thanks, Mark. It's really delightful to be here with you.
Okay, John, let's start with the first of the 3 cases, Oklahoma Statewide Charter School Board versus Drummond. This was one of the 2 cases this past term involving religion and public education. It had the potential to shape the law around religious charter schools, which I think is why advocates on both sides put so much energy into the case. We actually did a symposium on it here at the Mattone Center. But the court ended up in a 4-4 split without an opinion. John, what happened in this case?
Well, the key development was Justice Amy Coney Barrett's recusal. She didn't tell why she recused. Justices really don't often do that. But I think the most plausible explanation is her connection with Notre Dame, where she had been a long-time professor. And that law school's religious liberty clinic was deeply involved in the case. And without her, the court split evenly, which left the Oklahoma Supreme Court's decision in place.
Right, and the decision in the Oklahoma Supreme Court was that St. Isidore, which was a Catholic virtual charter school, was a public entity, and so couldn't be religious in nature because that would violate the Establishment Clause of the First Amendment. The school had argued, that is, St. Isidore had argued, that it was more like a private contractor, entitled to participate in the charter program on an equal footing with secular institutions. But because of the tie, the lower court decision stands and doesn't set a national precedent.
Yes, exactly. That's what's important to underscore here. The court's per curiam order here has no precedential value. It resolves this dispute, but doesn't settle anything more broadly. And that means this issue can certainly come up again.
Yeah, John, if Justice Barrett had participated, how do you think she would have voted?
Well, and I think this makes a lot of difference because this issue, I'm sure, will come up again. It's hard to know, but I think it's likely she would have sided with St. Isidore. I think for 2 reasons. One, I think that's probably the more logical view given the previous Supreme Court precedents. Moreover, you do have to be somewhat of a realist looking at Supreme Court justices, and Justice Barrett is well understood to be sympathetic to the role of religion in public life. So I think that would open the door to including religious schools in state charter school programs, and it'd be a major victory for school choice advocates. And I think it's important because allowing religious schools to participate may actually create more pressure, create a larger political coalition for charter schools. And so that issue's not going to go away at all.
Yeah, I agree with that, John. And I think that it's bound to come back. There was, I say, a lot of resources were put into this case, kind of fizzled out, but I agree with you. I think it'll come back. Okay, that's the first case. The second of the 2 religion clause cases this term was a case called Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission. And that case, too, could have been more consequential than it turned out to be. In the end, in that case, the court ruled unanimously and narrowly, probably unanimously because the court ruled narrowly. John, what was the Catholic Charities Bureau case all about?
Well, the question was whether Catholic social service agencies in Wisconsin qualified for a religious exemption from paying state unemployment taxes. By law, the state exempts nonprofits that are, quote, operated primarily for religious purposes, end quote. But Wisconsin argued that these particular Catholic organizations didn't qualify for the exemption because they didn't operate primarily for religious purposes. And what made their failure to be primarily religious was they didn't proselytize or limit services to Catholics. That's what made them not religious.
Yeah, so in effect, John, the state punished these charities because they serve the broader community. If they had kept their services only to co-religionists, they would have been okay under the Wisconsin statute, but they didn't. They served the public at large, which ironically is what their religious convictions compel them to do.
That's right. And the court saw that as theological discrimination. It held that the statute drew distinctions among religious organizations based on their internal doctrine. That is, whether they emphasize evangelization or inclusive service for everyone. That sort of theological discrimination triggers strict scrutiny, the court held. Wisconsin couldn't meet it. It didn't have really any good reasons at all.
Yeah. I think it's interesting that Justice Sotomayor wrote the opinion for the court in this case. I mean, she's one of the progressive justices, and here she is writing an opinion which is, I guess we'd say, pro religion or pro religious exemption. I think that's noteworthy itself. Also, the reasoning was pretty narrow. It doesn't push the law very far. It affirms the principle that in granting religious exemptions, states can't pick theological favorites. But, that's not terribly controversial. In fact, John, reading the case for this podcast, it struck me how nonchalant Justice Sotomayor was about whether this should be seen primarily as an establishment clause case or a free exercise case. She sort of said, well, it's kind of both. So, John, it seems to me this case is a very good example of the court avoiding broad pronouncements in this area. One could imagine the court engaging more deeply with the definition of religious activity under the Free Exercise Clause, but instead the court opted really for a consensus around a very narrow proposition. Don't discriminate among religious groups based on theology. Okay, well, we all kind of agree with that, I think. Probably explains why the decision was unanimous.
Well, I think that's right. They go back to something that goes to uh, the beginning of the religion clauses, that the state has no business picking and choosing among religions. So that's what makes it an easy case and allows the court to exercise institutional modesty and unanimity. You don't have to go into a larger inquiry into the contours of religious exercise. That is a much more fraught project. Instead, it's easy for the judges to coalesce around that principle, a principle that really does go back, is at the heart of the Establishment Clause. And it's significant, of course, in its own way. It does reinforce the notion that religious neutrality is not only a matter of fairness, but of competence. Civil authorities lack the institutional capacity to evaluate religious doctrines. Moreover, it gets them into a position of seeming to favor one religious doctrine or another. So, in some sense, this was a very easy case. The surprise, in some ways, is that the Wisconsin Supreme Court decided the other way. And this is, I think, shows something generally about the Supreme Court. It's just a very competent court. And at times, lower courts, and I think sometimes particularly state courts, are simply less competent, and they make decisions that are simply wrong, and that really that professors across the ideological spectrum in their field would think are wrong. And the Supreme Court rarely does that.
Yeah, I would also say here that if you look at the Supreme Court religion clause cases, especially involving religious exemptions in the last few years, it seems to me they like to take narrow positions. They really are trying not to make broad pronouncements. And you were talking about being a realist a little while before. If you're a realist about this, I think personally they just don't want to inflame situations more than they are. Well, although of course the next case we talk about might be a counterexample to that. Okay, so let's come now to that case, which is I think the only one of the three church and state cases this term that could fairly be called a major case or a blockbuster, and that's Mahmoud versus Taylor, which is the parental opt-out case from Maryland. So, like the charter school case that we talked about a second ago, Mahmoud sits at the intersection of religion and public education, which is always a controversial subject. But the controversy has only grown in recent years as topics like sexuality and gender identity have entered public school curricula, including in the elementary schools. Unlike the charter school case, though, this case produced a full opinion for the court. And unlike the Catholic Charities case that we talked about just a moment ago, this was not a unanimous ruling, or I guess, depending how you look at it, a narrow ruling. So, John, why don't you walk us through the background of this case?
Well, here, the Montgomery County Board of Education, that's a county in Maryland around Washington, D.C., they introduced a series of LGBTQ plus inclusive storybooks. And they did it for students who were quite young, from kindergarten through fifth grade. Now, at first, the district allowed parents to opt out their children out of lessons. They allowed parents who had objections to this early kind of learning. But less than a year later, the board reversed course. It rescinded the opt-out policy. It said, well, very hard to apply. Particularly, I think there were so many people who wanted to opt out, and that would lead to disruptions. And it didn't even provide any advance notice to parents when the books would be coming up in class. Now, this didn't sit well with a group of parents from a variety of religious traditions. You might say from the Abrahamic religious traditions, Christian, Muslim, Jewish. So they sued, and they wanted to prevent the use of the storybooks without notice and opt-out rights. And they wanted also an injunction pending the resolution of the case. So this was decided on a preliminary injunction basis. They lost in the lower courts, in the district court in Maryland, in the Fourth Circuit. They ultimately went to the Supreme Court.
Yeah, and so it's interesting. I teach federal courts in addition to law and religion classes, and there are some interesting procedural questions here about injunctive relief, but we don't have to bother the listeners with those. The core issue here was whether denying these parents notice and an opt-out violated the free exercise clause. And the court decided by 6-3 in favor of the parents, holding that they were likely to succeed on the merits. The majority opinion is by Justice Alito, and there's a dissent by Justice Sotomayor on behalf of herself and Justice Jackson. So what did the court hold here? The majority opinion, again by Justice Alito, found that the board's refusal to provide notice and an opt-out substantially burdened the parents' free exercise rights by interfering with the parents' ability to direct the religious upbringing of their children without showing that there was a compelling reason to do so. The court found that the storybooks conveyed normative views about sexuality and gender that directly conflicted with the family's religious beliefs and not in a neutral expository way. Justice Alito wrote that the materials were presented in a way that was psychologically coercive for school kids. And by that he meant that teachers were encouraged to affirm the story's messages, for example, that same-sex marriage should be celebrated, and also to correct and even reprimand students who expressed disagreement. And he said this was a psychologically coercive thing.
Well, and I think it's important to note that in evaluating the burden on parents' religious exercise, the court relied on Wisconsin versus Yoder, a famous free exercise case. It comes from 1972. There, the court sided with Amish parents who wanted to entirely exempt their children from compulsory high school education. Now, it's true that Yoder has been a kind of doctrinal outlier because it seems so unusual. But here, the court reaffirmed that it had broad significance for parents. Alito wrote that the curriculum in Mahmoud posed a somewhat similar threat, even if the circumstances were different, because it placed religious parents in the position of having to counteract values being taught in school. So the religious traditions were in some sense under threat from public education.
Yeah, now the Yoder case actually talks about the existential threat to the Amish that compulsory high school education would create. So when they say this is just like Yoder, they really are speaking very emphatically about the threat here. I mean, just a little inside baseball. It is true. Yoder is, you can look at Yoder and say it's really three cheers for the Amish. That's what explains the Yoder decision. But the court said it actually extends beyond them. Also, just a little inside baseball. The court has in the past explained Yoder in terms of the so called hybrid rights theory. And that means Yoder is based in the free exercise plus some other right. In Yoder, the other right was parental rights. The court has never fleshed out the hybrid rights theory, and the Mahmoud court bypassed it entirely. It explained in a footnote that the hybrid rights framework really didn't make a difference in the case and so wasn't going to be discussed. We'll see. I wonder if the court will simply move away from this hybrid rights theory in the future. John, did you want to comment about that at all?
Yes, I think that's interesting because, of course, the reason they went to look at Yoder and they said that it didn't matter that this law didn't discriminate among religions, right? It didn't come under Smith. And so, one question is how does one reconcile Yoder with Smith? And Alito really doesn't give a theory of how to reconcile it. Now, of course, Alito is very unsympathetic to Smith. So, one way you could think what he's doing is trying to create a lot of exceptions to Smith to make it easier to overrule Smith, to say that, well, Smith has exceptions and therefore there's really no reason to keep with it. One other way, of course, of understanding this case and the way is that it really is, whether it's about hybrid rights or not, that it's about children, and that's different. But Alito doesn't really explain that either.
No, he doesn't. He just sort of says, okay, stare decisis. This is what, if it works for Yoder, it works here, and leaves it at that. Okay, so the court said that there was a substantial burden on the religion of these parents. That is, the failure to give a notice and opt out created a substantial burden. But of course, Maryland could still have prevailed under strict scrutiny, but it didn't. So, what did the majority say about strict scrutiny, John?
Well, I mean, Maryland tried to argue that it had, in fact, a compelling interest in fostering an inclusive and respectful learning environment for, I assume, students from LGBTQ families and for students who might be thinking about, even at that early age, about uncertain about their gender. But the court found that argument was weak. It pointed out the district continued to allow opt outs in other contexts. And so, actually, here we come back to the idea that a problem for the district in this case was a problem that we see in some cases where they do try, where the court might otherwise rely on Smith, that they allow opt outs otherwise. And so, it's really seeming to be more harsh to religion. And I think that inconsistency makes it very hard for the board to argue that the opt outs in this context would uniquely threaten its educational mission because it allows them in other places. And that's a very common move in strict scrutiny. You can't allow really any exceptions, because the exceptions will be held against you.
Right. Well, this is what some commentators talk about as a most favored nation theory of religious freedom. That if the state gives exceptions to anybody, it has to treat religion equally. It has to give it the most favored treatment that's given. And some scholars have complained about this. It does seem the way the court is moving in these cases, and this is a good example of how inconsistency and opt-outs can actually doom a strict scrutiny defense. Okay, let's talk about the bigger picture here now, John. I think this is a pretty important decision for reasons that I'll talk about, but I want to give you the first word. What do you think about it? Am I right that this is an important case doctrinally and even for public policy? For example, the dissent points out, schools can't function if every parent gets to micromanage the curriculum, which is what the parents were trying to do here. And after all, the dissent says parents can always opt out themselves can opt out by going to private schools or, doing homeschooling.
Well, I think that argument has some appeal, but the majority addresses it directly. In fact, it completely rejects the idea that it's an answer to go to private schools or homeschooling. That would be very burdensome for parents. Moreover, I think under the doctrine, that's kind of unconstitutional condition. You're requiring people to give up rights or give up the privilege here of going to a public school. And I think the key line in the opinion is that it's both insulting and legally unsound to tell parents that they must abstain from public education in order to raise children in their religious faith when the alternatives can be prohibitively expensive. After all, they already, as the opinion points out, contribute to financing the public schools. And so that's, I think, the key move that the court makes in the case.
Yeah. You know, John, one theme that really jumped out to me is the role of coercion. The majority, Justice Alito's opinion, takes very seriously the idea that impressionable children can experience subtle forms of pressure and maybe not so subtle forms of pressure that amount to a kind of coercive indoctrination. Now, what's interesting here to me is that in past Establishment Clause cases, and I'm thinking about Lee versus Weissman from like 30 years ago, that's one of the school prayer cases, or Kennedy versus Bremerton School District, the Coach Kennedy case from a couple of terms ago, another school prayer case. We see this debate play out in reverse. In the school prayer cases, it's the progressives who are more concerned about coercion and conservatives who dismiss it. In this case, it's interesting, the roles are flipped. The conservatives are warning about psychological pressure and coercion and indoctrination, while the progressives are saying, no, no, this is all about neutrality and the exposing of students to different points of views. What do you make of that shift in this case, John?
Well, I think it really depends here, is very dependent on the context. I think in Mahmoud, the conservative majority would argue that they're looking at the formative power of education in the early years and the really huge difference between the message that's being delivered to children as young as in kindergarten from what the message that their parents want to give them religiously. And they understand that this really isn't going to be neutral. I think at least the majority has the much better argument here that at least for students of these tender years, these books won't come across as a kind of neutral sociological exposure to these ideas, but a celebration of same sex marriage and the ability to transition from one gender or to another. And I think the dissent, by contrast, wants to argue, and I think somewhat contrary to fact, that this is really just exposing children to the differences in society, the pluralism. And they're very confident that pluralism in the classroom is inherently benign. And I think, at least with children of this age, the majority doesn't think that this is neutral and really can plausibly be neutral about these kinds of subjects. So when the state puts its thumb on the scale of certain moral positions, that can amount to de facto indoctrination, particularly when the children are so young. I think this decision might come out quite differently if the texts were in high school, for instance.
Right. And to be fair, John, actually, the two cases I mentioned, Lee versus Weissman and the Bremerton School District case, those both do involve high school. It's public school prayer, but it's public school prayer in a high school. Okay, John, now I know we were talking before we started to record that you wanted also to talk a little bit about the broader theme here of kind of public schools and traditional religion more generally. So why don't you say some things about that?
Well, I think one of the interesting things about this case, and it's been pointed out before, that the court is often very solicitous of, quote, minority religions, but this is a majority religions. It's really all the Abrahamic religions come together to sue about this case. And that, to one degree, shows that the dissent may have some concerns here. It's going to make it very hard, I think, to if a public school wants to present an LGBTQ curriculum with books like this in early years, it's going to make it very hard to do that. On the other hand, what's interesting about this is that here we're going way beyond what you might think the original ideas of the religion clauses are about, which is trying to get the state out of making distinctions in doctrine. Here we have the state that wants to deliver a message about morality that goes way beyond doctrine. And that's not surprisingly going to create a very difficult line between secularism and religion, because religions have spoken about morality. And yet, if the state wants to have its own view on a controversial subject of morality, that's going to make it very difficult for courts to figure out how to both allow the state to deliver that message without undermining religion. Because, as I said before, I think it's very hard to see these books as doing anything else than trying to set a baseline for children that there really are no differences between same sex and other and opposite sex marriage, and that gender transition is just something that anyone can choose, as they can choose other matters. They can choose to be a baseball player. And that is obviously sits very uneasily with the religious worldview. So I see this as a harbinger of difficult times to come under the religion clauses.
Well, I agree with that, John. And I do think that Mahmoud versus Taylor does suggest some deeply polarizing debates about these issues. And I think we're likely to see them recur. I think Mahmoud is going to shape the debate on education and religious liberty for some time, which is why I say of the three cases we talked about this podcast, this seems to be the only one that could be thought of as kind of a major decision or a blockbuster decision. Well, John, thank you again for joining me on the podcast.
Thank you very much, Mark. Delighted to be here.
And thank you, listeners. This has been another episode of Legal Spirits, which is the Mattone Center for Law and Religion podcast on cases and issues in law and religion. If you liked this episode, I encourage you to subscribe to the podcast. You can find past episodes archived on our website. That's lawandreligionforum.org. Also on Apple, iTunes, and on Spotify, and on our new YouTube channel as well. So I hope to see you again next time, but that's it for now. Thanks for listening.